All right, I'm going to get us started. I realize popcorn is a huge attraction. So go ahead and get your popcorn. Please get seated. I'm John Haig. I am the director of the Mostafa Rahmani Center for Business and Government. My background is in tech and reg policy to some extent. Certainly, I was at AT&T for many years, running P&O. We have today John Salet is going to probably do more of the moderating than I'm going to do. And I think all of you at this point, we've done so many seminars on tech and reg policy that you probably know John. But John is a terrific lawyer, lead counsel for the state of Colorado in the Google search case and the Google remedy trials. Wrote a lot of or oversaw a lot of the development of the briefs, and incredibly knowledgeable. And I don't know if he'll want to talk about it, but he's got a lot on his plate coming up here soon. And then we have Ori Schwartz and the OECD competition division. He's the head of the OECD competition division, which is a huge undertaking. But John can walk through more of that, and then we'll do our usual. We'll talk, ask Ari a lot of questions, and then we'll open it up for all of you to ask questions if you have any desire to do so. So with that, John, you want to?
Yeah, thank you, John. So today we're here to talk about dynamic competition and the evolution of AI markets with a global perspective. The snack is to demonstrate that we intend to serve you both kernels of popcorn and more than a few kernels of truth. So we'll be in good shape. And we're very lucky to have Ori Schwartz join us in pursuit of that. Just briefly to note, we're very lucky to have Ori here. We've been working on it for a while, but schedules haven't always coincided. And today, having Ori here is a great pleasure. Ori has been head of the OECD competition division since 2021. And this is a very significant multilateral responsibility, overseeing work to promote competition enforcement, pro-regulatory policies, and supporting the OED's competition committee. Ori comes to this with a background that includes work as as the chief legal counsel at the Israel Competition Authority, which of course oversees competition policy enforcement and regulation, and in 2015 and 2016, serving as acting director general of the Israel Competition Authority. His background includes obtaining a master's degree in law from the Hebrew University in Jerusalem and a second master's degree, this one in European law and economics from Hamburg University. We asked Ori here today because John and I, in conversations with you all, have been thinking about how competition dynamics are evolving along or across, or however we envision an emerging AI value chain, from upstream inputs like compute, downstream applications, Gen AI, or more specialized apps. And what we've seen from the OECD under Ori's leadership is a series of explorations of emerging sources of market power, vertical relationships along the AI stack, and the potential for competition bottlenecks and risks. So we're very pleased to have Ori here. But before we dive into the issues, if it's okay, for people who might not be so familiar with the OECD, can you give us some overview of the OECD as an institution, and then we'll go into these specific questions?
Sure. First, thank you both so much for having me today. It's a pleasure and an honor to be here at Harvard Kennedy School. So just starting with a few words of self-promotion about the OECDs. The OECD stands for the Organization for Economic Cooperation and Development. It's a multinational organization that its headquarters is in Paris, France. It has 38 member countries. And the reason I'm mentioning it, because unlike other similar organizations, this organization is being run and managed and owned by the member countries. So we are all focused on different policy areas. We're focused on creating standards, but the standards that we create and the policy that we do is not just something that we do for ourselves. We are getting the support and the promotion of our member countries. And when the OECD adopts best practice, it's not just the organization that adopts it, it's the governments of the member countries. Now, the OECD works across, well, we used to say everything except defense and culture. I'm not sure anymore about the defense side, since it's becoming, I would say, unfortunately, more and more popular in policy discussions. But we do a lot. We work on very economic areas like competition, tax policy, corporate governance, and so on. At the same time, kind of more social topics like health and education and labor, and so on. And the way that we work is that we have committees. So around every topic, we have a committee, and committee is basically a group of representatives from the governments of the member countries. And we, as OECD staff, support the work of these committees. And my responsibility is to support the work of the OECD Competition Committee, which has representatives from all competition agencies across the OECD, usually at a very high level, at the level of the head of the agency. And yeah, that's roughly it.
So we're going to start asking some questions, but just let me emphasize, we would love to have questions from anybody here, students in particular, anytime you want to ask a question. John and I will start with some questions, but please do participate. But let me just start by asking, you've been seeing a lot of changes in AI, the subject of the reports I mentioned. As you're thinking about the work of the OECD, what's striking you as particularly important or interesting about, for example, the evolution of Gen AI?
So if we try to think about, to unpack this massive topic, which is called AI in the context of competition, and along the lines that we've drawn in 4 different policy papers that we've released, and by the way, everything that we do is available for free online. Just, I wouldn't say Google, I would say use your favorite search engine. And
which 90% of you will use Google at least. But
now, why would you say that?
I have a monopolist perspective on some of these issues.
So kind of to divide the AI world into 3, we'll kind of, maybe I can suggest the following. We can first start with the inputs into AI. So think like the infrastructure, the chips, data, cloud computing, so on, the things that feed in to the AI world, even things that are not very intuitively connected into AI. For example, like energy. AI has a massive influence over energy markets. Then also things like talent. In the AI markets, talent is a crucial component, and we've been seeing, for example, in the context of competition, agreements, I dare not say mergers, where one company acquires basically the staff of another company, so to acquire the talent that the other company has, in order to kind of acquire this talent and promote itself in the AI era. Then we have the AI markets themselves. So the LLMs, the foundation models, the actual platforms on which AI or Gen AI is being provided, either to consumers or to businesses. And finally, and perhaps most enigmatically at this point, are the downstream markets. Because AI feeds into many, many different markets. And we'll talk about the influence of competition later, but we can have issues such as vertical integration in these markets. But also, if you completely take outside of the picture the AI markets themselves, just the influence, the competitive influence that AI may have on different markets is enormous, very diverse, and we are only now starting to realize this implication. So very broadly, this is how I would set the stage.
I haven't talked to you about this question, but it occurs to me if I could ask. So when you explain, and I think this is important for everybody to understand, the OECD is working with competition authorities all over the world, operating under their own national laws with their own domestic economies that may have different imperatives to them. It's early in the game, but have you yet seen any of the competition authorities with which you work start to engage with AI issues?
Yes, very much so. Um, I would say surprisingly enough, or maybe not surprisingly, given that this is a new issue, given that even those for whom AI is the kind of the main expertise still have so many question marks over the development of AI, and we see anything from apocalyptic forecasts on the way AI will influence our lives to very positive ones. And so what we've seen so far, mostly from competition authorities, are studies, research. And I mean, you look around, I don't think, I haven't checked it, but I would guess that there's no other single topic on which competition agencies have published so many different studies in such a short period of time. Just to give a few of them, the European Commission, even here in the US, the FTC, Portugal, Hungary, France did a few, the UK did a few. So it seems that this is the first, perhaps the first attempt to deal with this vast knowledge, with these very rapid developments that are taking place, and try to have a very preliminary picture of competition concerns, which obviously are the main focus of competition authorities. So for now, mainly research. Having said that, very recently, we may be seeing a shift in approach. And we are seeing the beginning of enforcement. Very preliminary steps are being taken. Perhaps the most common example I can give for that is Meta and WhatsApp. As you may know, recently Meta decided to change its policy with respect to integrating third-party AI chatbots into WhatsApp. And it made this option no longer available after being available for a while. And several competition agencies, namely the Italian Competition Authority, the Brazilian Competition Authority, and recently also DG have took actions, have announced that they are starting investigations, also considering interim measures, which is quite, in some jurisdictions, quite uncommon. And very, very recently, just last week, the Brazilian competition authorities have announced that it's already imposing daily fines on Meta until it allows, again, third-party chatbots to go back into WhatsApp. So we have seen also another investigation that, again, DG Comp has announced, looking into the way Google is integrating its own AI tool into its search engine and the way it addresses the possible rights of publishers of content on the Google platform. So I don't know at this point whether we see this shift taking place, or are these just few isolated cases, but it seems that things are happening.
So I think we need to, I know we want to get to some of the substantive questions about how to regulate, how to think about this from a competition perspective versus a regulatory perspective. But I want to plant a seed in the back of your mind. I'm struggling to figure out how you think about any kind of integrated global governance of AI. And just, listening to that conversation, when I think about the OECD and you're trying to get convergence of 38 countries around a set of policies, I have a hard time imagining how that can be done. And I guess from an OECD comp perspective, what you do, are you providing facts into the committees and the research aspects you describe? Are you proposing policy questions that the committee needs to address? Are you providing policy prescriptions that you think are the most reasonable ones? And how do those play then back into the sovereign decisions that nation states are going to make in these areas?
So thanks. First, we have no power.
You don't have policy-making power. They just have
we can only convince, have good arguments, and try to convince our members. It's ultimately their decision whether to follow, whether to pursue a certain best practice, whether to promote a certain best practice. We can certainly support them and make suggestions and work with them along these lines. Just to give an example, last year, this is, as you noticed, as was hinted in your question, a very complicated international arena these days. Having said that, last year we were able to gather a consensus around a new best practice, which we call recommendation. In OECD language recommendation is a best practice on merger control, which is quite comprehensive. It amends a previous recommendation from 20 years ago, which was very, very basic and focused mostly on procedural aspects of merger control. But we have now a quite comprehensive recommendation on that. And we managed to get this consensus because, well, first I would say compared to other policy areas, competition is still an area where consensus can emerge, not on everything, not in every case, but in some cases. And if you look at the big picture, you see that taking into account the last 20 years, the world is moving toward more convergence, at least in terms of from a competition policy perspective. I wouldn't say that we can do that on every policy, or on every aspect of competition policy, but we're certainly trying to push in this direction.
So the example you gave is very helpful about what proceedings you're beginning to see. But what one notes about them is those are well-established companies, Meta and Google, who have been, the subject of competition enforcement in non-AI markets, sometimes successful, sometimes unsuccessfully. And in some sense, the question of incumbents could be framed as, are they using incumbent monopoly power to affect evolving market structures in AI? That's one possibility. But there are new entrants into AI, right? This isn't just the old guard of platforms. Are you seeing the competition agencies around the world begin to look at issues involving any of the new players, or studying the kinds of issues that could be affected by new players?
Yeah, so in one of our papers, we looked into the investment agreements, for example, that certain you may know, this industry requires in many different parts of it a lot of investment. The investment of a kind that very few companies in the world can make vast amounts of money. And as a result, we are seeing a lot of investment made by certain firms in other firms, especially these new players are now enjoying funding from established players. And some competition authorities have looked into that. As far as I know, no action has been taken so far. Obviously, from a competition perspective, when you have competitors investing in one another, it might create an issue. It might create a kind of interdependence. It might undermine free competition. But maybe taking your question on a more broader, on a broader level, when it comes to emerging new technologies, there's always this trade-off that competition authorities face: when to intervene. And if you intervene too soon, you may undermine the development of the sector. And when it comes to AI, I mean, I cannot stress enough how prominent, important the sector is. I don't know if we'll get into it. There's also geopolitical aspects to the development of AI.
Yes.
So again, intervening too early or too soon might create a problem. At the same time, if you intervene too late, their markets may be entrenched. Then dominance may arise. And when you try to intervene, it might be too late.
Yes.
So intervention might be too late and too early at the same time. And this trade-off, I think that is something that often competition authorities have to manage. It's sometimes I think that it's a bit unfair to them because it seems that so many of us, not just us, everyone, everywhere, have huge question marks of the development of AI. But they are in a position when they need to make a decision. And as you know, not making a decision is also actually a decision. Not intervening or kind of adopting a wait-and-see approach is a decision. And if I go back to the kind of the example that I mentioned about these investment agreements, I think it showcased very well this trade-off, because on the one hand, we're saying these investment agreements create interdependence, and they might, in the long term, undermine free competition. On the other hand, capital is crucial. And if you try to block or intervene, you may end up with these new entrants not having the necessary capital to promote, to progress, to develop their platforms. And you may end up only with these players who do have the required capital, which well, we know them.
So can I talk about this for a second? Is that all right, John? So look, this is the number of people here
from our class.
who took our class, Big Tech and Competition, last fall. And one of the cases we discussed 2 days after it was handed down was the Meta Platforms case, the WhatsApp and Instagram case in the United States. And we looked at that, and some of the people thought we were kind of seeing Goldilocks. Like it had to be not too early and not too late. It had to be just right. Because in 2012, the FTC clears the Instagram acquisition. The judge's opinion certainly seems to suggest that he believes that Meta, through that acquisition, had monopoly power in a network of personal social networking for some period of years. TikTok enters the US in 2018. He says maybe there was still monopoly power in 2020, but not in 2025. So a couple of observations people were making about that. One is there continuing harm from a time when there was a monopoly, even if there isn't one now? But secondly, does that put a premium on looking at issues early? And the thing about that case was, and the similar FTC closing of a Google investigation in 2013, is there was a lot of discussion then, I'm told, I'm too young to remember, but in 2012, 2013, about how mobile was going to change all the market structures. And we ended up, at least in the United States, with 2 operating systems and basically 100% of the market. So I guess this is a long-winded way of asking, how do the competition authorities think about the way in which competition enforcement can anticipate problems when they start to hint which way they're going to go in order to escape the trap of seeming to come to the game late, right? That's a very difficult issue given the trade-offs you've articulated.
Yeah, but I cannot agree more. I'm just perhaps sharing a personal experience. In I think it was 2015, I attended the ICN annual conference, which took place in Portugal. And this was a completely different time when it comes to assessing big tech and their impact on competition. There was a lot of enthusiasm in the air due to the disruption they brought into markets. The theme was disruptive innovation, kind of the Schumpeterian notion of innovation and competition. And I mean, we need to recognize that in many senses, they did bring a lot of competition into many markets. But at the same time, the pendulum was perhaps too much on one side. And then at a certain point, and already at this point, there were few investigations going on. But with time, the realization that new market power is arising on the other side by the same platforms that were initially all about bringing competition into markets have started to settle down, and you saw more and more cases. There's a common argument that interventions by competition agencies with digital platforms was not timely enough, but that's difficult to measure, right? Because you don't have the counterfactual.
Right.
But I think we're seeing the exact same phenomena when we look at AI.
Right.
This kind of, are we too soon, or we may be too late? And again, I think you put them in a position when they have to assess future developments that even far bigger experts on these fields find it difficult to assess.
So, I naturally find myself going back to my old AT&T days and thinking about the structure of the AI tech stack and where the different components are. And so, how do you kind of think about regulating that or enforcing competition policy or thinking about industrial policy to make sure you don't get it monopolized, right? And by that, I mean, if you think about the infrastructure, the compute infrastructure, you can't play in that category unless you're spending huge amounts of money, right? So the major players are spending like $500 billion, I think, in each year, the next few years, to build out that infrastructure. And if you look at what many of them are trying to do, they're trying to move into, for example, they have foundation models. They may even be building towards applications. So they're doing the vertical integration, that you mentioned earlier. And you're starting to see some of the foundational models like OpenAI trying to get back into the compute side of the equation. You've got NVIDIA playing both sides of the, getting into compute, trying to tie it with software, trying to then build it into foundational models and the circular flow of money around all of that in terms of deals. So I have a hard time getting my head around what kind of approach is going to be most effective in getting the balance you were just talking about, the Goldilocks, kind of problem, like, because you don't want to stifle the innovation, right? And it's very hard to predict what's going to come out of all of the activity. But at the same time, you don't want to allow a Google, which I think is probably the most likely scenario. Google is vertically integrated and may very well build the most powerful moats. The current state of affairs may simply embed their monopoly position even more so. So how do you think about that from an overall, how do we manage that competition? And I know that's a big question, right? But how do you think about managing that? Where would you focus? What kind of aspects of it would you think are most critical?
Well, unfortunately, I don't have the answers, but I can maybe highlight a few things to consider. And I think you basically mentioned most of them. We talked about market competition in this sector, and this was the first time that we mentioned NVIDIA.
Right.
Which is a bit odd, perhaps, that it took us half an hour, considering
it's the largest equity value in the world,
and it's have quite a respectable position within the chips market. But so you have this firm who's doing very well, to say the least, in the kind of chips design market. It's perhaps only goes to show how complicated these markets are, because NVIDIA is a chip designer. Most chips are being produced in Taiwan by TSMC. So again, super complicated. And so one way that we've been seeing some of NVIDIA's customers trying to deal with this dominance is to try and enter themselves into the chips design market. So you have who are these customers?
Google is trying to produce its own chips.
Not exactly your new shiny competitor, but firms that already have quite strong positions in other markets. So how do you manage this trade-off? On the one hand, you have a market which is clearly concentrated. On the other hand, the potential competitors going into these markets are also quite powerful. Vertical integration in their own markets has been a major issue. I think some of the current conversations that are taking place within the competition policy sphere talk about the need to use perhaps divestitures in order to separate some of these or break some of these integrations. And of course, to make things even more complicated, especially recently, you have on top of that geopolitics and industrial policy, because there's this perception that there is a race, the AI race, is kind of, you can look at it from a US-China perspective. So we need to make sure that we get there first. I'm not sure exactly where there is, but wherever there is, we should be the first one to get there. And the industrial policy perspective, more and more countries are talking, jurisdictions are talking about tech dependence, not to having to rely on outside suppliers, at least perhaps rely on suppliers, foreign suppliers, but to a smaller extent. So trying to manage this, of course, this is certainly not directly, perhaps not even indirectly, the responsibility of competition agencies or of governments. But yeah, I'm sure I haven't answered your question, but maybe only raised more complicated and additional questions on top of it.
One of our students will solve this problem when they get out into the world.
Anybody want to ask a question? No? Well, you're going to have to keep listening to us. No. I'm sorry, just one second, because we're bringing your mic over.
We have people online, and so they can't
got
hear
it.
you if you don't use.
So on the Meta issue where they were required to accept third-party chatbots integrated into their service, I'm curious about the broader rationale there and how it would apply in other circumstances. The one that occurs to me is Google. You mentioned they have the search, effectively a search monopoly. They also integrate AI in their user interface now. When you do a search, you get AI results. So why would not the competition authorities mandate that Google make third-party AI services, give them access to Google as a way of displaying their own version of AI-generated results? Is that the kind of thing that might be plausible, plausibly, mandated?
John may not want to comment because he's, but
well, the question was not directed to me, so I'm going to let the
Ori gets to go first, and then I have a point of view I want to share.
But well, maybe we should suggest inviting an enforcer here next time, and an enforcer can answer this question more directly. But as I was saying at the beginning, I think there's a lot of uncertainty also from an enforcer perspective on how to address these questions, and intervening too early is also a risk that they're taking into account. I find myself wonder why. I mean, enforcement has to start somewhere, right? So we need to have a first case, whatever this first case is, and perhaps there will be additional cases. Some of them may be similar to the case that you're, I think, quite naturally suggesting. One possible, why was the first, generally speaking, one of the first cases dealing with Meta and WhatsApp? Perhaps because in the past it was possible for third-party chatbots, AI chatbots, to go on the WhatsApp platform. And then at a certain point, Meta decided to change its policy. Perhaps it's an easier case. I'm just speculating here. And I think this is work in progress. So is this a possible case, what you're suggesting? I think absolutely. At some point, a competition agency might consider moving forward with such an investigation. And as I've mentioned, there's already an ongoing European investigation into Google, not exactly from this perspective, but more the ways that they're using publishers, content publishers' rights and content, and feeding the kind of this content into their search engine, into their AI engine, without allegedly providing or paying sufficient compensation for these publishers. But we'll have to wait and see.
So if you take Google as an example, and you take what it's doing with Gemini and what it does with search, basically it's able to integrate. So you go on and let's say you go into Gemini and you ask Gemini a question about the Iran war. And Gemini is trained on data that was probably in place before the current Iran war, so it won't have that data in its response. Google does have 90% search, traffic, and it can integrate that search traffic into Gemini's response. So it gives you, not only does it have an integrated bundle, it has better quality of service that others can't replicate. It has a lot of kind of dynamics in the business model, right? So if you think about the content creators, the people providing the content that Google searches, now what happens? Well, somebody goes in, they go to Gemini, they get the search data, and they don't go, what Ori's alluding to is, they don't go to the search mechanisms to the people that are publishing the data, right? And they're just getting an answer, right? And so what does that do to the content creators? They're in this, somebody described it the other day to John and I as a Hobbesian choice, right? They either live with it and have difficulty monetizing their content, or they delist from Google and then they're not on the web, right? And it's a real Hobbesian choice on the content creators side. And then Google is building a stronger quality of service than other foundational models that you might go to look for information on the Iran war. And this is my concern about it potentially just embeds the moat, embeds Google even more so as a monopolist. Now, what's the solution to that? It's a complicated solution, but I find in my mind, I go back to, I'm going to date myself here, but remember what happened with Microsoft. Microsoft tried to integrate its operating system into all the applications, right? And make that a unique, and what happened was the government forced them through an agreement to open up the interfaces, the APIs between the so other people could build applications onto that. There's, in my mind, I don't know the details in my own head yet, but there's some kind of way of opening up those kind of equivalent of interfaces that makes some of the data sharing and the capacity more open to other players, so that you don't allow them to bundle these things together, create unique interfaces that others can't play into. But that's my version of how do you manage the vertical integration within these systems. I don't know if that makes sense to you.
Right, it does, and again, when there's more kind of technical layer of a competition discussion, say, okay, now we need to impose remedy. Should we try and police the way a platform uses content, uses its platform, integrate its platform with other services that it provides into this ecosystem? Should we seek a more structural solution for these problems? Some very interesting ongoing cases.
Yeah, Paolo. Oh no, I'm sorry. First, but then Paolo.
Do you deal with and following on John's question about regulating, do you think the regulatory framework that competition authorities have right now is sufficient, or do you publish recommendations of amending the existing laws, or should we just go with them to the courts and let the courts give their interpretation of the existing, how do you see it, or have you dealt with it? Thank you.
Sure. So there's a very big debate ongoing. And as you may know, in some jurisdictions, they adopted ex-ante regulation tools to deal especially with the market power of big tech, namely the DMA in Europe, the DMCC in the UK, and others. In the US, it's considered, at least under the current administration, it's considered to be quite unpopular. So, and by the way, there's an ongoing kind of discussion in the EU whether the DMA even applies and to what extent it applies to AI on the relevant markets for AI. So I wouldn't, as there's a big, let's say, there's some controversy over it. I would not take any position on that, but just say that it seemed to me that there's an agreement, at least on the problem, which is market power of certain players. And there can be different solutions. If anything, I would dare say that perhaps for these type of problems, of the AI type of problems, the flexibility that traditional competition law brings along with it is perhaps better suited. But yeah, I don't know. I wondered, John, what you think?
So I have a view, and then we're going to go to Paolo because I promised. But I have a view about this. I think there's an appropriate role for regulation in the world of digital. I think we're confronted with different ways to do it. The European approach is generally viewed as more prescriptive. The UK approach is viewed as more consensus. So I think regulation ought to have both qualities. And there was a time when I worked for the Federal Communication Commission where we wrote regulations on net neutrality, which was a hot issue at the time. And we thought about our state of knowledge. We thought there were some practices that we really knew were going to be, we believed that they would be harmful to competition, and we didn't have to know much more. But we also knew there were going to be emerging issues, for example, in mobile. This is the same time frame, mobile. But we didn't know how they were going to play out. So we came up with a regulatory scheme that had two parts. There were certain things that we said are presumptively illegal or prescriptively illegal in the way the DMA operates. Self-preferencing is illegal. But then we said we ought to look at other practices and whether they are going to have the kind of harms that the FCC is there to prevent. And we'll look at them on a case-by-case basis. And after I left the FCC, but Tom Wheeler's here a lot, he issued policy statements, his thoughts about some mobile practices. I think there's a place for regulation. I don't see any better way to do it than that. Because if we only go consensus, then it can take us a long time to discover what we already know. When we can't think we already know stuff, we don't. So I think we have to have both of those tools in a single structure. And I think we have to be very, very focused on Ori said this, on the dangers of inaction as we watch issues develop. Okay? There are risks in moving too early. In the US system, though, you've got to get in front of a court, even if you're a regulatory body. And so one never wishes to act haphazardly, but there is a process by which the regulatory action can be examined. And I think regulators need to understand that waiting can cause serious difficulties. For example, there's a new paper out by John Cuoco, who teaches at Northeastern, and Tommaso Valetti, the former head economist at the EU, on mergers, consummated mergers, trying to break up companies, well, like the Meta case, right? Trying to come in and say you should divest Instagram after the fact. And their policy prescription is act early. So I think we need a lot of thought about how to act early, but responsibly, right?
The one thing I want to add just real quickly on what John was saying is it's particularly difficult in this environment where the rate and change of AI technology is so rapid, and the rate of the ability to either take an individual case through competition policy, antitrust, or even to create legislation and regulate is so slow that it's really problematic, and it puts a strong premium towards acting early, but the institutional mechanisms to do that are not necessarily in place.
We promised Paolo the next word. Or words, Paolo. Have more than one.
Thank you so much for the discussion. Right, back on the risk of inaction and Facebook, Instagram, but taking it to NVIDIA. Yes, the Googles, the AWSs, and the Microsofts are developing their own chips, but there were new entrants like a Grok with a Q, and that has been acquired by NVIDIA. And it sounds like it's very similar to a Facebook, Instagram type of situation. Why aren't we seeing more discussions about this case?
Well, on this specific case, the simple answer is that I do not know. But there was a big conversation taking place, I think it's a few years ago already, on the kind of Meta, Instagram sort of mergers that focus on killer acquisitions.
Mm-hmm.
And the idea, there was a reason, I think, at the time when this, if we go back to Meta, Instagram, when this deal was brought before competition agencies, they didn't see the risk. And perhaps rightfully so, because the notion of a killer acquisition, so just to say for those who are not familiar, killer acquisition is, and I'm using my own words here, and we have a paper on that if you'd like to read it, is basically a well-established, you might say, dominant firm buying at a very early phase a potentially new competitor in the market. And when the actual acquisition is taking place, Sometimes it's below threshold because it's just a startup which is being bought. It doesn't have a turnover, so it falls under the threshold of merger notification. And even if it does, it's well before this new nascent competitor has managed to fulfill its promise and to become. So it's very difficult to block such mergers using traditional tools. And some competition agencies have worked with their governments to adjust their legal framework and to give them the opportunity to block or to intervene at a later phase with respect to such merger. In the US, surprisingly, this is not a problem because in the US you can litigate a merger at any point, but this is not the case in other jurisdictions, in what we call administrative jurisdictions. So to your question on the particular merger, I really don't know, but I can only go back to the trade-off, which I mentioned earlier, that if you have, again, it's not, especially in these markets, having good technology, being young and strong and energetic is not enough. The resource that you need to have to make it are enormous. And I mean, the gap between the well-established players and the new ones is, yeah, you need to overcome it somehow, usually with some investment from the established players.
Anybody else at the moment? So can I ask you, you referenced industrial policy, which is a thing, no question. How are you seeing competition authorities around the world coming to grips with industrial policy? How is that working out?
We were talking earlier, and when we teach our class, we talk about 3 mechanisms to control competition, right? We talk about ex post competition antitrust policy, we talk about ex ante regulation, and we talk about industrial policy. And those 3 things don't always get linked together. So if you can address John's question, but kind of put it in that framework, that would help us with our class next year.
So interestingly, I mean, it's interesting that you say that, because if you perhaps ask the common competition enforcer or competition expert about industrial policy, they would do something like, what?
Right.
Because there's this notion that industrial policy is all about funding these zombie firms that should have left the market, many times state-owned. But this is not what industrial policy is, actually. Industrial policy is about improving the performance of usually a domestic sector in more than one way, more than just through subsidies. But having said that, I think competition policy has always had complicated relationship, I would say, with industrial policy. And in a paper that we wrote 2 years ago, we highlighted that that should not be the case. Integrating competition perspective into industrial policy can actually be very pro-competitive. It's all about the way you frame industrial policy. For example, do you choose the winner or do you choose the battle? Do you say, I want you to do something, or do you say, I want something to be done, and then everybody can compete for doing that? And I'll support whomever is doing it the best way, most efficiently, and so on. So I fully agree that competition policy and industrial policy should be much more aligned together. I think the more complicated question is the vice versa one. So how competition, perhaps enforcement and competition policy is being influenced or should be influenced by industrial policy. And we've touched upon geopolitics, and that could be a serious consideration standing behind industrial policy. And you can see in principle points of friction between the two. For example, you have a merger between 2 domestic players, and you have an alternative merger with a foreign player. The 2 domestic players, merger might create concentration and market power, but at the same time, if it's important for your national security, then you want to keep it domestic, right? Allowing a new competitor into the market, a foreign competitor, might be very beneficial from a competition perspective, but may bring with it risks to national security. So this is a very general example, which, again, we need to see how it can be managed in reality. But I think the other way around, the way the competition policy is willing, or to the extent to which it's willing to consider industrial policy consideration, is still an open question.
I think we have time for at least one more question. Padmasree.
Thanks. My question is a bit related to this. So when you talk about the right moment to intervene, okay, and you talked about getting there, to what extent can competition policy take into account all the costs of getting there? For instance, employment costs or energy costs and so on, especially when you start talking about this friction between industrial policy and competition policy, because clearly, when you have these industrial policy investments, you're going to have all of these and tech race, you're going to have these fallouts. And if it's not competition policy, what policy should be taking care of that? So that's one question. The second one, which is related, is that, in this, whether it should be competition policy or industrial policy, a third question comes up, which is, I know it's not the right time globally to talk about it. It's a theoretical question. Do we need a baseline to think about what is there in terms of AI? Do we need a global or broader consensus about what are the limits to which one should consider regulating AI or going there with AI? And what is the discussion in the OECD about some sort of common policy consensus on this? And do you think it's affected by the fact that China is outside of the discussion? I mean,
spent a lot of time addressing each of your questions. Let me start with the first one. I think that's a really good question, and I think a question that competition agencies are constantly struggling with when they are asked to consider something else, some other public interest on top of what their bread and butter, which is competition. And there's an institutional aspect to this question. Do they have the right tools to address this, whatever industrial policy, whatever you want to call it? Because I would dare say that every few years it changes. The other thing that they need to consider, and it's fine because policy changes and priorities change. There's a legal question. Can they, legally speaking, say, going back to the example, the merger that I gave, can they say, okay, there's an anti-competitive merger here, but from a national security perspective, it's much better. So we are approving this merger knowing that it's anti-competitive. Most jurisdictions, that would be very difficult, to say the least. And perhaps then there's the kind of policy perspective. If you want to, as you can see, I don't have answers, only more questions. Who should make this decision? Is it a decision for a competition agency, for a competition enforcer, or is it a question for governments? Politicians are the ones which are balancing policy priorities. And perhaps if you have a transparent and open process saying, okay, we're willing to accept this merger of two domestic firms that might create market power, but for our national security, it's more important than having a competitive market. In my personal view, that's a fair decision to make. The question, who should make it? And of course, the way that, procedurally speaking, the way this decision is taken. I don't know if you'd like to add more.
I want to make sure we get a chance if anybody else has a question.
I didn't answer your second question. Sorry.
That's all right. John and I will have plenty of time to talk with Padmasree and try to figure this out at some point. So.
John, did you want to add anything to this?
I'm good.
So I feel like we are right about at time. Is there anything you'd like to do? Is there anything that we forgot to ask you that you've been thinking we need to educate everybody on?
There's so much I would like to talk about, but yeah.
We'll have you come back for like a semester or something.
Part two would be enough. Yeah, just to mention, maybe to go back to the question about regulation. I wanted to mention it, but I had then the opportunity. One of, I think, the most interesting markets that are involved in the AI section is cloud computing. And we issued a paper which is exactly on that. And you see there's some very interesting phenomena that are taking place that goes back to a question of why we don't see more enforcement. One of these practices was what they call egress fees, where a competitor wants to take its data out of the cloud computing provider, it has to pay a fee. The fee can be potentially conceived. Of course, it's a switching barrier because it's a price attached to moving from one competitor to another. And there's this claim going on that these fees are all about, or mostly about, being switching barriers. Some jurisdictions are already tackling them, and mainly in the EU, there is regulation that is not only on that, but the Data Act, which is going to ban such fees from being charged by cloud computing suppliers. So in this sense, of course, one might say there are other negative costs associated with regulation, but I think that's an interesting example, and one of very few examples on the way regulation is already tackling some of the challenges arising from these markets.
I should note, when you mentioned the report on competitive implications of industrial policy and how to have industrial policy that promotes competition, that was a reading we used in our class, and it was extremely well done and very helpful. So for all of that and for appearing today, thank you very much.
Thank you.